what we're going to do today, just like we did last time, so welcome everybody. Great to see you all. We're talking about the changes to the Victorian Strata Act today with Alan Ferre from CHU and also Richard Eastwood from Smarter Communities. What I'm going to get you to do, please, is obviously ask questions along the way. If you put your mouse down on the chat button down the bottom, that's where you can actually then ask me a question. Please keep it strata related. Last week we had some about building maintenance and that kind of thing, and so of course that kind of like was off topic. I hate to say that, but what we would like you to do, please, is actually put your question into that chat box. We actually have got some people on board today who are from CHU Insurance, and also Richard, who'll actually then be, so Quinton and Scott, and they'll actually be responding as we go as well. But what I might do is actually pull a couple of those out anyway, just because it might be an interest to the rest of you as participants in this group session. So what I'm going to do is I'm actually going to share my screen. With the slideshow that we have. So for some of you who may not know of us, the Australian Apartment Advocacy has been around for 5 years, and we actually are also the voice of people who actually do live in apartments. So we provide advocacy services. We actually will get involved between an apartment owner and a strata manager or a builder or a developer or somebody else within the building, God forbid, and actually provide that liaison service. We provide an education kit, which we just created for Victoria. We do research, and we lobby government for more and greater protection. So we're actively lobbying in Victoria and also in Queensland at the moment. So we're definitely keen to make sure that everybody who's actually living in an apartment has their rights protected, especially in regards to defects, and especially in regards to, especially if your builder has features, which some of you have. So there's the education kit on the left-hand side. It's for apartment buyers and owners. If you haven't downloaded the kit yet, please do that from our website. And like I said, we're going to be creating a dedicated apartment awards for excellence, and we're looking to roll that out in Victoria. There's a people's choice in there, which is for owners corporations and body corporates to nominate if they feel that they've got an outstanding committee. So if that's the case, please put yourself forward for that. So tonight's session, we're going to be actually talking about, as I said, the Strata Act and the changes to the Victorian Strata Act. Do your questions via chat. The session is being recorded. We have got a capacity crowd of 320 tonight. It was 500 last week. And so it just goes to show that there's certainly a great deal of interest from everybody in regards to this topic, which is great. So Richard, I'm very pleased to have him on board today from Smarter Communities. He's the Executive General Manager and responsible for all the brands in regards to the Smarter Communities portfolio. He's an accredited practicing strata manager, so he does know what he's talking about, even though he's come from a banking and finance background. And then we've got Alan, who's obviously been with CHU for 13 years now. For the last 10 years has been regional manager for Victoria, Tasmania, South Australia and Western Australia. And he's actually been in the insurance industry altogether for 28 years. So welcome both to Alan and also to Richard. Thank you for joining us tonight. Now, Richard's going to speak first, so I'm going to let Richard take over the screen, and I'm just going to push the down buttons as we proceed. So Richard, let us know if you're ready to go.
I'm ready to go. Can you hear me okay, Sam?
We can, darling, we can.
Excellent, excellent. Well, let's flick across to the first slide if you can. And thank you very much for the invitation to speak. And I think where we're at with the changes to the legislation or the amendments, I think this is I'm always pleased to see a group such as this and the size that we're talking about here that are getting involved in owners corporation and I suppose the proposed changes. The benefit to all of us about a better educated workforce or team members and also client base is that we have the synergies that operate. And I think it's very, very pleasant to be able to see this many people turning up to the session.
Sorry, Richard, just before you go in, there is some feedback. So I know Sammy did ask, but maybe reinforce if we could all hop on mute. I reckon we'd enjoy Richard's session a lot more.
Yes, everybody, please put your microphones on mute unless it's just myself or Richard or Alan. Otherwise, you will get this kind of echo, and we don't want that, especially since we're recording tonight's session. So if you haven't got yourself on mute, please do that. What you need to do is go to your microphone and actually pop, I'm going to do a couple of these anyway. All right, Richard, I might need to unmute you, darling, because I actually muted you by mistake. All right, go ahead, Richard.
Oh, you're still on mute, I'm afraid, Richard.
Thanks, Al. Yes, I think it's good that we've got this many people involved, and I think probably what we have done today, what VBCS has done is we've got, as Sam was mentioning before, we've got Quentin Thomas, who works with us as a consultant. He's got a law background, and you'll see in the chat room, he's going to answer the technical questions that we're coming to. What I wanted to do today is give you an overview, and the overview goes into some detail, but specifically in the way that the legislation or the way the amendments are going to come through. There's going to be some technical questions that are going to come through. What we're looking at doing as part of a strategy that VBCS are doing is we're also going to be communicating to all of our client base within the next fortnight to 3 weeks. We're going to put out a more detailed communication and go out to all of our owners to make sure that we're trying as best we can to cover, I think, some of the changes that are in force, and obviously give our owners better understanding of what's going on in more detail than we're going to be able to go through into a presentation like this one. So you can see how I've broken it down, and if we flick across to the next slide, Sam. One of the things, and this is a bit of a composite, this is a slide that I pinched off Alan from last week. What we wanted to do is give you a baseline of where we're at. So what you're looking at here is the changes to the, or the amendments to the Act itself. The commencement date is as of the 1st of December. So that's a hard date. From the 1st of December, these new provisions are coming into play. It has taken a long while for these to be enacted. And obviously with things such as COVID and governments being busy doing lots of other different things, it has had an impact and potential delays in enacting what is, I think, some common sense decisions that we're sort of moving through with. I think the other thing, next slide, Sam, please, is some of the major changes and the reasoning for the changes is to really look at the industry itself and really look at how it's evolved. From when I started over 20 years ago now, we've gone from not having emails all the way through to pretty much being driven by all sorts of technology options. What you also see is the change in the development that's come around strata. And one of the major things that the amendments look at doing is be looking at, okay, what's the change in the industry, and how does that flow through to, I suppose, the legislation that oversees the running of strata itself. So 20 years ago, it was mainly smaller type buildings out in the suburbs. Now, with the development along those growth corridors, you know, we've got buildings either flat or high rise that can go up to the hundreds of lots. So what the government have tried to do is to be able to cater for the different types of buildings themselves. So what you've got is a tiering system. The tiering system talks about, and they've broken it into 5, everything from a building that's over 100 lots all the way down to just the 2-lotter, which sits out, generally speaking, further out of town. So what they've done is they've given a tiering system that allows for different treatment depending on the different sizes of the buildings. We'll go in a few minutes to the type of building or the type of, I suppose, adjustments that have been made. But really what it's doing is saying, okay, the way that you might run a smaller block is different, and the protections need to be different for the buildings as they increase in size. Far more protections are required in those places. Next slide, Sam. And so you can see here. So we've got the smaller blocks. We've also got the largest. So what we're looking at doing is I suppose the way that we're treating those buildings from the two lotters all the way up is a different structure to be able to protect them. Next slide, Sam. And what we're talking about here is, particularly as you're dealing with those larger buildings, where generally speaking, the blocks of hundreds or more, you're talking about a completely different entity to smaller blocks. The requirements are still very similar in that we still want to make sure that buildings have got maintenance plans and that they're set up and they've got the right, I suppose, treatment, that they're managing themselves correctly. But when we start talking about a building of over 100 lots, the amount of funds that's held in one of those owners corporations is extremely substantial. So what we need to do, what the government have done, is that, okay, if we've got a tiered site, let's look at a different restrictions or a different ramifications on a smaller as opposed to a larger one. And so you can see from a financial reporting position, from an audit position, which we'll talk about in a minute, but the structure and the systems of what's in place for those buildings is adapted depending on the size of those buildings. Sam, next slide for me. Importantly, very importantly, and as I say, in those larger sites, we're looking at buildings that can be multi-million dollars or have multi-million dollars, ready to be doing the maintenance plans, ready to be making sure that, you know, they've got their normal expenses or their normal income covered. So what they have done is they've said, okay, for a building that's over 100 lots of occupiable lots, and by occupiable I mean it's an actual apartment. As Strata has evolved, we've not only got occupiable apartments when people live, we've also got car parks. Strata works across a lot of different dimensions. So with those larger sites, so those ones over 100, they must have their financial statements audited. It's a substantial change from where we have been at the moment. The current legislation in Victoria says that you've got a prescribed owners corporation, which is over 100 lots and over a financial barrier, financial target. Anything under that, you were not required to audit. It was completely up to the owners corporation about what they needed to do, what they decided to do. So what the government has put in place is that for those larger sites, they must be audited. For a tier 2 site, and as obviously as we're cascading down, there's a different requirement. So you can see as the structure is moving through, it's giving different protection mechanisms depending on the size of the buildings. And as we see for even those smaller sites, 3, 4 and 5, they can be audited, but it's completely up to the owners as to what they choose to do. So they make those determinations themselves.
And I think that's important, Richard, because some of these larger apartment buildings, we're talking about, like, you know, in the millions of dollars, correct, in terms of what's actually happening with their sinking fund and their reserve fund and so forth.
Exactly right.
And also, you know, so Richard and I were part of the SCA working group that liaised with the government during these changes. And a lot of this feedback actually came from this type of audience, and which is individual lot owners. You know, it wasn't just esoteric service providers or academics or interested stakeholders. It's people that live in strata saying these are some of the things that we think are a really good idea to put some governance and protection in there.
Absolutely. And one of the important things, and when we spoke in our last presentation, we spoke about this, and because it's critical, it's the maintenance plans that sit around a building for a long period of time. And as I said before, at the moment, if you're in a block of say 90, there is no requirement for you to be able to have a maintenance plan. Even for what we call prescribed, so over 100, there's a requirement for you to table a maintenance plan. There's not actually a requirement for you to be actually enacted. It's really just a requirement for it to be tabled. What we have done now, and I think what the government has done, and as Alan's saying, due to also some of the politicking that's been done by the SCA on behalf of the owners, is to be able to say, as depend of the size of the building, once you get up to these levels, there are some maintenance plans requirements that need to be enforced, need to be set, need to be enforced, and importantly also you need the funding to be able to do them. So you need to be setting aside the finances to be able to do them. I think that's critically important. And as it sort of comes from a maintenance plan, whether your primary residence is a house or an apartment, you really need to be making sure that you're setting aside funds to be able to take care of the upkeep. There are quite a number of buildings that have, and these days, particularly when we're talking about expensive roof replacements, repaint, all the type of transactions that a normal house would go through or an apartment building would go through, you've really got to make sure that you've got enough funding there to be able to make sure that you can cover that. And the owners, because we all know in strata, people buy, people sell, there needs to be funding to be able to accumulate those. There's nothing, I think, worse than trying or buying into an apartment complex and finding that you've got a bill because you haven't put aside, or the previous owners haven't put aside the funds to be able to do that.
Yeah, and I think that sorry, Rich, that is a good point, and this is where, yeah, sort of say CHU really welcomes what you do, Sam, because the reality is, yeah, you're a real advocate for where the owners corporation have not got builders defect support where they should have done, and how to work with that. Obviously, insurance pays millions of dollars worth of claims every single week to fix stuff covered in an insurance policy. But I really like your philosophy, Sam, which is a recognition owners corporation have the responsibility themselves to provide some of the long-term upkeep as well, because you've always been a fairly firm advocate for that, haven't you?
Correct. Well, at the end of the day, you know, if you can't drive a car for 20 years and not service it, right? So how do you think you can live in an apartment for 20 years and not actually then spend money on it? So things like waterproofing or water membrane protection, they've usually got a lifespan about 15 years. Your windows have got a lifespan of about 20 years. Your lift has got a lifespan between 15 and 20. Your paintwork on the exterior of your building should be replaced after 10. So these are all elements that most apartment owners don't know, because you may not have lived in an apartment before, but at the end of the day, if you don't upkeep your apartment, what actually happens is your costs will spiral. They will go higher. The longer that you don't deal with something, the costs will go higher, and that then will impact on your property values. So please make sure that you get your maintenance plans in place, but that you actually start enacting them.
Exactly. Next slide, Sam. Budgets, and I think this is the critical important part of management of owners corporation and the way in which we need to make sure that we're funding ourselves as we move forward. We need to make sure that we've got sufficient funds to be able to do the things that we need to do. So we've spoken about maintenance plans. We're also talking, and we'll talk in a little bit more detail as time goes on, about how the changes are coming to play. Particularly, Alan's going to talk a little bit about changes to how insurance premiums can be treated, and also potentially excesses at the same time. But it's critically important, no matter with a change of legislation or without a change of legislation, that owners corporations make sure that they're correctly funded. And I think that's going to be a challenge, and has been a challenge over the journey. A lot of owners in the past have looked at how can they keep their fees the lowest possible. It's important, I think, to make sure that we fund ourselves properly. Next slide, please, Sam.
Sure. Sorry, I'm answering people's questions. So I just wanted to quickly say, Scott, darling, I've got some questions there. Can you please look at those for me? I have emailed you directly, but if you could just keep your eye on them, that would be great for me.
An important change that's part of the amendments is committees, and I suppose the valuable role of committees and how they're enacted is critically important to the running of an owners corporation. And this can go for anything from a smaller site right the way up to buildings that are over 100 lots. Committees are the decision makers for the owners corporation, largely enshrined in legislation, and critically important. The more involved they are, the more engaged they are, they're better. So you can see from the slide there that we talk about the minimum number of lots that requires an owners corporation committee. It's in place now, but it's being redefined. Also, the default of the default size of a committee. What you need to do is make sure that the decision making is succinct, that it is streamlined, and it actually is operating to the best needs of the owners corporation itself. And so what you can do, or what the amendment says, is that the committee, the default size is 7, so you've got a streamlined operation. What it can also do is say, okay, well, the owners corporation, by an ordinary resolution, which is done at an AGM, can also increase that number up to 12. But we obviously don't want to get to the point, if there was no limit, some owners corporations might turn around and end up having committees that were dysfunctional, by virtue of the fact that they were oversized. So some common sense decisions to the committee making process.
Richard, what's the minimum, please?
The minimum 3
Right.
of a committee, yeah.
I always love an odd number. I don't think 3 is enough, right? Because then what you actually have is indecision, right? Because one always wants to sit on the fence. But I do think 7's great, because then if you actually have 3, 4 and 3 against, your chairperson really is the person that should be making the deciding vote. But listen, I'm a big believer that your committee needs to actually think about this as a business plan, right? So I might sit on my committee for my apartment, and when I sit down, I look at that asset and I say, this is a $70 million asset. I'm going to put my business hat on. What's the best decision for this building? The number of times that I see committees say, oh, we don't want to spend the money, we want to save the money. By saving the money, what you're doing is actually putting your building into disrepair. So please do not think that by saving money, you're doing the right thing by your committee and by your lot owners. You're not. You have a right and an obligation to look after your building and the health of your building, and then the health of everybody who's living in that building.
Absolutely right.
Sorry, Richard, Sam, and also I was just having a look at some of the questions. There's some really, really good questions that I fully understand, but they might be at a level of details, some of them that we actually won't not be able to answer in the meeting. So if Scott and Quinton don't answer it, just because they may not be able to do for that particular set of circumstances. Just want to flag that out there. Don't want to inhibit the questions, but we may not be able to answer all of them because it's just a little bit too detailed for us to get into it in this presentation.
So if your question doesn't get answered, please email me and then I'll send it on to the right person to actually answer that for you, okay?
And I think we do come to the point, or I go back to the point that Sam was just talking about before. Some of the times with owners corporations and in committee meetings and AGMs, there are a number of decisions that the buildings need to make, where we need to be aware of having experts in place to be able to guide the committee in its decision making, whether it be on insurance and making sure that we've got the proper valuer in place to be able to put a correct number on it, whether it be an engineer. Oftentimes when we're talking about projects now, and particularly in the larger buildings, but even smaller, to make sure you've got the right advice from the right people to be able to make decisions, I think that's critically important. And sometimes we can save, potentially there's a I suppose a mindset to keep our expenses low. What we also are looking for is value for money, and that can come from making sure that you've got the right professional in place to advise the committee to be able to streamline things.
You know, the other thing too that we've got to be careful of with the whole maintenance thing is also, you know, I went to an AGM the other day and the committee had decided to not actually hire a specialist to kind of like create their maintenance plan. They were going to do it themselves. And my comment to them was, well, who of you on this committee is actually a structural engineer? Or which one of you is actually a specialist in waterproofing? Or which one of you is a specialist in lifts? Now, it was no surprise that there was none of those specialist services on that committee. So don't fool yourself thinking that, you know, well, we're an intelligent group of people. You may be a highly intelligent group of people, but at the end of the day, this is a specialist area. And if you actually have a critical situation within your building, the ultimate thing is the committee will be held responsible. So please do everything to protect yourself by getting the right specialist in to give you the right advice.
That's absolutely right, Sam. And can you tell me if I'm running a bit over time here or if I'm talking too much? But I think that it also comes to what we see quite often is quote requests. And so you'll have an owners corporation that will say they'd like a quote to repaint their building or to do a different task. Those tasks are really quite they're quite technical. And oftentimes you can say, okay, let's repaint in St Kilda a block of 10. We'll repaint it. Oftentimes you go out to a contractor and you'll get different quotes coming back from different contractors because the specifics that they're looking at are different. It's really got to make sure that we're very focused about the way that we go about doing things. And oftentimes that is engaging with experts. Next slide, Sam. One of the things with owners corporations, and sometimes I find it hard to believe, when we're talking about investments of hundreds of thousands of dollars, owners corporations, the number of people that would turn up to an AGM, I was quite surprised and have been surprised. The most people I've had turn up to a block of 100, I had no one turn up to an AGM. And I've also been, if you look even across the broader breadth of owners corporations, generally you get probably 10 to 15% turnout to an AGM. The level of I suppose, involvement from owners does sometimes bewilder me, which is why part of the decision making of the amendments that were put through have been designed in some ways to streamline that. A lot of the meetings that we hold are actually no-shows, and that's when people don't turn up to an AGM. It makes decision making very difficult, and from a strata manager's point of view, we'd rather people turn up to the meeting. We'd rather be able to have involvement from owners to be able to make decisions. We facilitate decisions generally on the behalf of the owners. We don't make decisions, and we can't make decisions on behalf of the owners. What the amendments do is allow for, if you like, for a no-show meeting. And that's effectively, we're given certain powers to be able to keep the flow of the building going on. So if no one turns up at an AGM, these are the types of things that we're able to do. Obviously, the more people that turn up, the better we like it and the more we're able to do. But there are, I suppose, provisions that are put in place just in case we don't have the turn up that we're looking for. Consumer protection, and this is something that is, it's topical at the moment, and it's been topical for quite a period of time. Defect management is one of the things that that we're seeing more and more of in the media. We've seen a lot of it in Sydney. What you also know, you should know, is there's a lot of it in Melbourne as well. So any building where it's you're taking occupancy, there is, generally speaking, there's going to be defects. The way in which defects are addressed is oftentimes a quite significant process for the developer, for the builder, and for the owner's corporation back to work with the strata manager. So you can see from this slide what they have done is there's two things that have happened, and it's designed to be able to make the treatment of defects more effective.
Okay.
I
Just
also
remind you,
yes.
Because maybe his pant is so tight,
Yeah.
he has over here on the tummy, not a
I don't know.
Someone's got their microphone on. Could you please mute your microphone? We can actually hear your conversation.
Yeah. If you can't, I think it might be Nico. I think that's, if you can see the name from your end, Sam, I think.
I'll have a look.
Yeah. It's very hard for
okay,
they had a leaking, you know,
yeah,
from the pending. So we just try to tight a little bit.
No, it's okay.
Can you move them?
From the hair.
Okay,
from
I'm going to mute all,
because
and then I'm going to unmute you, Richard.
Thank you.
Great, thank you.
So yes, the treatment of defects is a major issue, and as I mentioned before, we anticipate that going into a new site, a new build, that there are going to be defects. How you manage them is critically important, and that's why there are some protection mechanisms that have been put in place. You can read specifically this one, and it's about not having the developers being able to vote, because that has been historically a problem. On the next slide, Sam, what you'll see is also the ability to be able to take action against defects. I think last conversation that we had talked about defect management and owners corporations understanding who is responsible for defects. Obviously in sites, we've got common properties, we've got also the individual lot. So it's having a strategy to be able to, I suppose, manage defects. It's quite a complex subject, to the point where at BBCS, we're looking at changing our structures to be able to have someone that is able to assist us through with defect management, because it is extremely complex. Lots of builders these days are putting in their own strategies to be able to streamline them through, the good ones, because they do know that it's part of their customer service to be able to deliver it.
Yeah, and I think, Richard, the bit about the voting for the builders is where there's been scenarios, say, where Alan Ferre was the developer. Alan Ferre keep 60% of the units, and every time that there's a defect I just vote against it because it's not on my interest to do so. I think that's what the government's trying to avoid. So the other 40% are unfairly penalised because I had the numbers. I no longer have the numbers, do I?
No, and I think that's so important, because time and time again we'll actually see a developer actually hold onto lots and lease them out until the 12-month defect liability period is over, and then he'll sell, and that will allow them to actually have voting power, which is a big no-no in my books. So if you're actually having that problem with your developer actually trying to rule the roost and vote against defects, or even do things like reduce the council of owners down to a certain number, that's when you call me, because I'm the Aaron Brockovich of Apartments, and I will help you out. All right.
And for us Victorians, Council of Owners is the committee. All right, Sam.
Oh, sorry, Sally.
Yeah, that's okay.
I think rules too are important, and I'll diverge off this slide, but only for a moment, because I think it pretty much speaks for itself. This is about empowering owners corporations and making sure my divergence comes from, I think it's critically important for owners corporations to have governing rules that protect them. Now, I think it's there are, like, they're called model rules. So the government does put in typical rules that cover all buildings, all sites. I think it's also important for buildings to have registered rules that particularly pertain to them. What we do is we work with lawyers to be able to design specific rules, and you can see even from the terminology that you're seeing here, you can actually make rules that specifically pertain to your building. So that means that you've got an individual focus. You're then able to, if you do have an issue, be able to go to a tribunal to be able to make a judgment. But it's critically important, I think, for buildings to have a foundation on which they can build, and on which, as owners come in, leave, you've got a commonality that sits in there, and you've got rules that are able to be applied. I think that's something that we do in inception, or should be done in inception, but it's also something that I think needs to be reviewed every few years as technology changes, as time changes. I think it's important. Now, they're not easy to do. Rules are something where they are technical, and you normally would need a lawyer to be able to oversee them, but it's critically important for mediations or judgments to be able to have something on which you can base your decisions.
But it's also, I think, Richard, a fine line on the rules side between having rules that work for the harmony in the community they're building, but not crossing that discriminatory line. That's where VCAT get very, very, very edgy and defensive when they see those type of rules trying to be enforced, isn't it?
Absolutely.
I had someone last week ask if they could stop someone having barbecue smoke. No, you have to be a tolerant strata, like a tolerant strata lot owner. And that means that, you know, I was talking to someone this morning, and she said to me, if her next door neighbour smokes, she just shuts her door. Like, it's a bit annoying, but you know what? You have to be tolerant. And that's what it's about, living in a community that goes up rather than along the street, right?
Absolutely. Tolerance also comes to abandoned goods. Now, this is one where sort of like we're amending legislation. So abandoned goods, whilst it might not be seen generally as being something that is a pain point, it certainly is a pain point for owners corporations. And what that means is, when you've got tenants leaving, when you've got owners moving, the amount of personal items that get left on common property, it's a specific amendment that has been made to be able to give the owners corporation power to be able to remove goods and do what they need to do to be able to keep common property free. You can sort of see where this is coming from. It doesn't mean that that owners corporations are able to engage people to just come in and remove. There's a process that fits into play, but it also gives the owners corporation the ability to be able to make decisions and be able to remove abandoned goods that have been left and dumped on site. So a good amendment, quite small, but a good amendment. Now, my summary, just quickly. I think it's very topical for the government to be revisiting and making amendments as time goes by. And what you are seeing, these amendments that have been put in place have been years in the making. I think what they have tried to do is probably adjust as the market's grown, and you can sort of see from larger lots to be having that tiering system, I think is a critical one. To be able to empower the maintenance funds, I think is a typical one. So I certainly do applaud those. What it also comes to play is sometimes the complexity of managing owners corporations. I think that's one of the things, and I say there in the last paragraph, I think it's important to make sure that you're getting the right professional advice when it comes to running your building. I think oftentimes there are sites where they say they'll self-manage. To self-manage and not be able to be able to interpret the plan of subdivision or the legislation means that you can cost yourself thousands of dollars into the long run because your foundation is not correct, and you can be paying for works that are not the requirement of the owners corporation, and vice versa. So it's critically important to be able to get the right advice.
Richard, darling, I have moved you along, but thank you very, very much for that very thorough coverage. And I think that, as you say, we're going to be having to kind of like put out more and more information as we move forward, as we approach December. This is a big adjustment, but one that we obviously feel very glad about because, as you said, both yourself and Alan have been involved in this, and it will provide greater protection. So I'm going to hand over to Alan now, darling, if you want to talk about insurance.
Yeah, thanks, Sam. Thanks, Richard. And also, as Sam said, look, Richard and I have spent, and this is 6 or 7 years worth of working and making through, I think, the 3 government elections since then time. So it's been a long time for this legislation to come in, but credit to the government. A lot of what Richard went through is where they got the feedback from, like, people on this call who live in strata, said, these are our stress points. These are our pain points. It's nobody repairs stuff. Who's going to pay for it? There's, the stuff gets dumped on common property and quorums and people not turning up. So whilst Rich has gone through it relatively succinctly and thoroughly at the same time, these are the real points that the government got the most feedback on. And then we walk into something, look, there's not fundamental change on insurance. Insurance has always been the key aspect for our owners corporation to protect their assets and meet their legal obligations. Richard had a slide earlier about 2 lots and under, which are exempt from the insurance side, but the reality is for people living in a 2-lot strata is your financial risk and your ability to be sued by a third party is no different. So we would encourage you to make that decision because it makes good risk management sense for you to have the right insurance in place. One of the changes is an increase from public liability, and public liability is if the owners corporation are found liable to a third party for damage to person or some damage to property that the owners corporation have to pay, and that's gone up from $10 million to $20 million. Not a particularly big increase in premium. It's probably about $70 in total. But what the government are recognising here is that firstly, a lot of stratas in Victoria already buy up to $20 million for the advice they get from their broker and or strata manager. And it's just a good way to protect the financial interests of an owners corporation. Because if something does happen and there's not enough money, the way the legislation is written is the owners corporation is unlimited, has an unlimited liability. So any shortfall insurance doesn't pay will pass back to the owners corporation and in turn back to the individual members. From a CHU side, we are increasing that free of charge. This is quite technical, but I'll take you through it anyway. This is where there are multiple owners corporations on one plan. So there's maybe an unlimited and a 1, a 2, and a 3, and a 4. It's always, you tend to find those insured under one policy. Now there is a right for those to be split out. But what it's really worth bearing in mind is there is a real economies of scale from a pricing and making sure there's same cover across all by having it under one policy. So yes, there may be a right there to do it, but before the owners corporation look to do so, again, come back to what Sam said, get some advice from somebody who can really guide you through the insurance implications of the decisions you're making, because just because you can doesn't always mean that you should, and you need to make informed decisions.
Correct. And I think that's where your strata manager really comes into play. You know, even though you may not have to have a strata manager involved because of the tiering system, for me, I think they're worth their weight in gold, because they will tell you whether or not that's within the Strata Act. And even just looking at the questions that are coming up here on the chat, there's a lot of misunderstanding or people not quite informed. And that's where having your strata manager is so important.
Yeah, and when it comes to insurance, the strata manager will often utilise the service of an insurance broker if there's a particular specialist advice they need to get as well.
Correct.
Yeah, and again, yeah, the multiple single dwellings on a plan, it gives some rights that weren't there before. If there's a strata, let's say the boundary of the strata, the obligations of common property and liability are the same, which there must be insurance in place. But if there's individual standalone dwellings that aren't deemed common property, there is the option to have insurance individually. But again, it's likely to be more expensive, and the cover may not be as comprehensive. And also there's a lovely word in there, Richard, I'll be welcoming your feedback. It says the words, a unanimous resolution is required. Richard, you've been doing this for 20 years. How many unanimous resolutions have you seen taken by an owners corporation?
Alan, I don't think I've ever been involved in one that's actually passed. They are extremely rare. They're easier to obtain in a smaller site. The smaller the site, obviously, the easier to get owners on board. But no, very, very difficult to get, Alan. Very difficult.
Yeah. So again, it's an instance where there's an additional right there, but it's just be careful how that gets managed. And valuations. Richard's made reference.
Alan, can I just chime in there? And it's going back to where you came from. It's like I also think there's a lot of value in the owners corporation coming together and being able to insure itself collectively, and to be able, it's not something that I would encourage for owners to think, okay, well, I'll look after my own requirements. There's a lot of benefit from being able to come together as an owners corporation, be able to make your decisions collectively rather than thinking that you can do it individually.
Yeah, thanks. Because some of the realities of that one is everybody knows that there's cover in place, because if Alan chooses not to buy, well, the other 4 light owners might really regret that if my house gets burnt down and it's just an empty shell sitting there. So, and it's just the realities again of communal living. Richard made reference earlier to prescribed owners corporations of the current Act. That's the only obligation currently to get a valuation, and the valuation is to work out what the correct sum insured should be on the insurance policy. But at the same time, the owners corporation's got responsibility for full reinstatement and replacement. So those things have always been hard scales to juggle. So this now, I think recognises that and puts the onus back on now a lot more owners corporations to actually get a valuation to make sure they're adequately insured to protect their financial asset and meet their legal obligations. It's 5 years in the Act, but say every 3 years is normally good financial prudence, because you're not doing it for resale value, you're doing it for reinstatement and replacement value. And that can be quite volatile if there's labour costs or if there's material costs that go into play as well. And multi-level developments can get a valuation for their section if they're only buying it for their particular owners corporation, but it does make sense to do it collectively.
Alan, what we've also seen in the past is at an AGM, owners getting together and trying to come up with their own sum insured, and I always, well, don't shake my head because that's not appropriate, Alan. But I would always come back to, you know, if you're valuing and you're putting a value on your property, it's not worth your while sitting there and having a think about what should it be valued at. It's a technical skill set, and it needs to be done by someone who actually understands the market and what needs to happen. So oftentimes it's one of those things before about, you might think that you're saving a few dollars to be able to come up with your own sum insured. The risk associated with doing that is extremely significant.
Yes, it is an extreme risk, because if there's a shortfall, Alan, who pays for the shortfall, darling?
The owners corporation will pay for it themselves, and then each individual lot owner are responsible for each other. So it could be the last person standing if everybody else decides they haven't got the money.
That's right. So, and that could be in the millions. So that's why you take out insurance, right?
Thanks, Sam. Look, this is quite, sorry, Sam, can we go back one slide? It's quite a technical slide.
Yes.
So that's what it says in the Act. If you go forward to the next one, let's go, what we message we're trying to get across here. So what the government have looked to do is that I think normally, currently, Richard, most bills are paid by a lot unit entitlement or liability. Everyone's got a number. That number equates to percentages, and that percentage is what you'll pay out of a particular budget. I think that's how it works, isn't it?
Yep. Part of the plan of subdivision covers it off. And if you're in a penthouse at the top and you've got a bigger floor plan, generally speaking, you pay more. So that's the way that they generally break down the expenses of an owners corporation. Yep.
Yeah, and also I think, Rich, it's fair to say that insurance is normally one of the highest expenditures in a majority of owners' corporations.
Absolutely.
So what the government trying to do is there are some instances where it's deemed one particular lot might be making everybody pay more. We see it most often in the commercial property side, where there might be a high what we call a high hazard rating occupant within the commercial, where let's say it's a woodwork manufacturer. So the government's trying to give some flexibility for that one lot to pay more than the lot unit entitlement liability basis. But it's also quite clear how that needs to work. It says there must be negligent, and negligent, only a court of law can decide that. Just because Sam thinks Alan's negligent because I've had a claim, that doesn't mean that the owner's corporation can force Alan to pay more. So, and also, you know, it's potential for an owner's corporation. Yes, if there's a high claims on the policy, the likelihood next year your premium will go up. But it might be me making a claim this year, but next year it might be Richard, and the year after it might be Sam. It's what insurance is there for. So what we really hoping this doesn't do is actually create a lot of conflict when people are trying to point their fingers at each other and say, well, you've done this, that, and the other and pay more. So I think, Richard, you'd have a really good example where you have seen this before. And again, it's mostly on the commercial properties where it's quite clear that one particular lot is doing something inside their lot, which is pushing the premium up quite heavily. I think that's where you would see this might come into play most often.
That's right, Alan. So you've got a commercial site where one, and I can't remember the example that we used last time, but it might be they might be either making or selling fireworks, and the other commercial sites are just doing normal transactional based stuff. So obviously, when you're advising the insurance company that there's going to be this high risk transaction that's happening in that lot, that's when the other owners will turn around and say, well, hang on, where our risk is lower than that person's risk or that lot's risk, so we want to break away, or how can we actually adjust for it?
Thanks, Richard. So again,
negligence comes in now, isn't it, Alan?
That's right. So again, it's a right, it's an option, but it needs to be used judiciously and appropriately. Somebody actually, I just saw a chat pop up about commissions, and this is where I'm going to cover that off.
Yes, I thought CHU can deal directly with an individual owner's corporation.
Yeah, we can do so. And let's CHU, we will distribute through an insurance broker, would distribute through a strata manager, or distribute direct with a lot with the owner's corporation. It's the customer choice model.
Yeah.
And really, what Section 122A duties of manager from an insurance perspective, it's affirming what the law is already under the Corporations Act, which is in most instances, within a strata manager or an insurance broker will get paid a commission for arranging and placing insurance. It's normally 20% that's paid to the strata manager, and a broker may put a fee on top of that because it's appropriate for them to do so, because obviously they're not a not-for-profit organisation. But what's really clear is owners' corporations should be kept fully updated and fully informed about what commission is being paid to service providers to arrange and place an insurance on their behalf. And if there's anybody who feels that's not the case, sit down with your strata manager and be upfront about it and ask. Sit down with your broker and ask. There's a legal obligation for them to do so already, let alone the ethics and fiduciary duty of acting on behalf of the customer. And it's not something that should be swept under the carpet in any way, shape or form. No. Because from my understanding, and Richard, I welcome your feedback, strata managers get their income mostly in three ways. They get it from fixed management fees, from variable costs paid by the owners' corporations, and insurance commissions. That's broadly your revenue model, isn't it, Richard?
We strata managers we facilitate on behalf of the owners, and we do it in a number of different ways. One of them is we're part of the insurance distribution channel, if you like. So we're the ones that sit at AGMs, and we're the ones that work with the brokers or work directly with CHU. So we're actually part of the model. So yes, we pay an insurance, yes, we do get an insurance commission, but generally speaking, it's because of all of the work that we do to facilitate between the insurer and a broker, if that's in place, and the owners' corporation. So we're part of the process, and we're remunerated. We're not shy about it. There are disclosure requirements. It's in all of our management agreements. We act in the best interest of the owners' corporation to get the best price that we can for their insurance. And we employ individuals within our business that are specialists in dealing with insurance. So we do play a vital role in that transaction.
Yeah, thanks, Richard. And yeah, this is really sort of a wind back from New South Wales legislation, which says the owner's corporation must get 3 quotes on insurance. And now what it is for recognising that the option the owner's corporation takes must be competitive. Competitive is subjective. If you wish to get 3 quotes, get 3 quotes. If you're happy with one particular service provider, go with that one particular service provider. But again, just make sure, this is what Richard was saying earlier, it's incumbent upon the committee to be proactive and involved, and that will allow them to make decisions that's best for you.
I do advocate getting 3 quotes, Alan. I think it's always good to compare apples to apples, but as long as then what you're asking for is in fact apples to apples, right? So that's where your valuation is really important. Once you know the valuation of a replacement cost, that's when you can possibly go out and get your 3 quotes.
And I think, Sam, that the extension of that, because that's the way that the amendments are written, it's not only just on insurance, it's on all transactions. And the manager has a responsibility, and it's detailed, to be able to make sure we're getting the best price for the owners corporation. And we take that very seriously.
Great. Alan, thank you. As always, very, very informative. I'm just conscious that we're kind of like losing people as we get towards the end of the hour. So now, just for everybody, just upcoming events for us from the Australian Apartment Advocacy. So tomorrow we're talking about green leadership with Strata. We've actually seen a company actually providing Strata owners with access to renewable energy, which has reduced their fees without having to pay for any infrastructure costs. So that's on tomorrow. The 4th of November, we are looking at the investor and what's happening over 2021-22, and that's with Biz Oxford Economics. The 11th of November, we're talking about financial forensics for Strata, which is very timely, considering the audit requirements under the new Strata Act. And then 26th of November, we're dealing with a very riveting subject, mould, and how you might circumvent that both before and after, because unfortunately we are seeing a bit of mould occurring in apartments due to obviously ventilation. So I would actually like to thank my sponsors, of course, Smarter Communities and CHU are in that mix. I must declare that. But I'm very grateful to them, because I wouldn't be able to do what I do without their support. What started off as a part-time gig 5 years ago is now my full-time job. And I do love doing it. And I certainly love being the advocate for apartment owners and the easy breezy lifestyle, as I call it. So please, this is my email if you'd like to reach out to us. If you have any questions for Alan or for Richard, please channel them through to me on this email address. And then what I will do is actually then get that through to them. So if you want to register for any of the sessions, that's where you also should email me. And that way then I can register you for those as well. Alan and Richard, any final thoughts before we sign off?
I think actually I'm going to say still something Richard said last time, and it's that we've got 131 people involved, and the fact that we've got this many, that shows how much care and passion. I think, Richard, you put it really nicely about how you felt with having lot owners involved and taking an interest, and what a difference they actually make to this sector.
Absolutely, and I do. It is one of those things where, you know, I said before, 10 to 15% of owners turn up to AGMs, etc. You know, it's the decision making, and it's the people that get involved and have a passion. Not like us, because we're strata nerds, Alan, but they generally have a passion for their investment and for their property, and for doing the best for the communal living. It's generally speaking, it's an unpaid gig to be a committee person. But you can really, you know, you're really bringing value to an investment, to a site, and I recognise, I appreciate the work that goes into committees.
Yes, and I think, you know, I'm very grateful for both of you, because even though you are strata nerds, darlings, and gorgeous strata nerds as you may be, you have given up an hour of your time outside of work hours. And I'm very grateful for your input, and I'm always grateful for your insight. And certainly, you know, as we move towards December, I think we'll probably have to host a session on building maintenance plans and how we implement them. I think that's going to be very, very important. So thank you to Alan, thank you to Richard, thank you to Smarter Communities and CHU for being such gracious hosts. And I certainly look forward to seeing more of you as we kind of like move forward with our events. Stay safe, Victoria. Enjoy your freedom, Victoria, and look after your communities. All right. Thanks, everyone.
Thanks, Sam. Absolute
Thank
pleasure.
you.
Thanks, right.
Bye now.
Bye now.
Good night.
Thanks, everybody. Have a lovely evening.
Thanks, Alan. Thanks, Richard.
Thank you.
See ya.
Thank you.